Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Yep. All right, this is case number 24142028. This is Mary Elizabeth Thomas versus Virginia Park Housing. The matter is before the court, set on the basis of filing a motion. I believe I had it set for a pretrial conference as well. There is a motion to dismiss the complaint or for plaintiffs to file a more definite statement that has been submitted before the court. Your appearance for Virginia Park, I believe, if I had counsel, your appearance, please.
Judge Coleman, James Gromer, P63503 on behalf of the plaintiff.
Thank you, Mr. Gromer. You said for the plaintiff, correct, sir?
No, I lied. It's for the defendant. I'm used to being the plaintiff. My apologies.
Yeah, I figured we get it all straightened out at one point or the other. All right. I'm looking for Mary Elizabeth Thomas. If you want to assume, please say something at this time.
Mary Thomas, I'm here.
All right. Good morning to you, Ms. Thomas.
Good morning.
I'm looking now at a motion that was filed to dismiss her for a more definite statement. I see that as of June the 10th, I have the receipt of a first amended complaint that has been submitted to the court. Counsel, have you received the amended complaint, sir?
I did. I received it yesterday by email.
All right. At this point, that would seem to make the motion to dismiss a good issue in as much as there was a request, an and or for a definite statement. Is that about the size of this, counsel?
Normally I would say yes, Judge, but as a brief sort of recitation here, we had a previous case before you, exact same basically complaint. You ordered her in January 2nd to essentially fix it. She didn't fix it. You dismissed it on January 23rd. Ms. Thomas was clearly not happy. I don't think that she quite understood why, that it wasn't following the rules. I knew, or kind of sort of guessed, that she was going to refile the case and quite frankly look for a new judge. And so I reached out to her and explained to her the court rules as it's required to notify the court of a previous action so that it would return back to the same judge, which is of course proper. She ignores my emails. I put that as part of my motion. She did exactly what I thought she was going to do. She filed the case and ended up in front of the Honorable Judge Robinson. I filed a motion explaining obviously what had happened previously. He moved that to you. You filed or set the hearing date on March 22nd. And I understand that she's pro se or pro per, but it's essentially the same order from January. My client has spent nearly $4,000 on motions. And then I receive, which I'm just going to be candid with the court. My least favorite rule, court rule or otherwise, is Michigan Rules of Professional Responsibility 1.2B1, where attorneys can sort of halfway practice law. I find it to be problematic. I'm old, I get it, but you're either in or out. And so, and it's confusing. It's confusing for people that are within the court, and it's confusing for attorneys. So John Holler sent me the complaint yesterday. I have plenty of respect for John Holler. He's an attorney. Obviously, we're all familiar with Mr. Holler. And, he tells me, here's an amended complaint, which is I think pretty obviously drafted by an attorney. And I'm sure it's Mr. Holler. And, you know, he's not representing her at this time, he tells me in his email, which is convenient, right? Because, you know, if even though, Judge, you've granted 3 months for them to respond, you literally set this 3 months ago for them to respond to the motion. At a minimum, they're required, depending on service, to respond 3 or 5 days before the court date. He responds today or yesterday. She's pro per, right? So everybody sort of at times thinks, you know, the rules don't specifically have to be addressed. He's not representing here. He's also, by the way, and please make it clear, I'm not representing, and I'll tell Mr. Holler he needs to fix it. He's required, according to the rule, to notify if he's in fact drafted these documents for her. It's required. I'm back to the court rule. So we have a motion. She's supposed to respond at least 3 or 5 days before. They did until yesterday. 1.2, and he's not here, right? So, and I emailed him and asked him if he drafted these. He's not in there. And the reason that I'm so strange about this rule is, you know, I end up dealing with people, and then I show up to court and they tell me they talked to an attorney, and I just dislike the rule. But if we're going to use the rule, I think we should follow the court rules. And so I never get court costs and attorney's fees. I get it. I understand on pro per, but you know, my client legitimately, we're the same spot we were in January. All right. You were kind enough to dismiss it without prejudice with her. You explained to her what she needed to do, not only on January 2nd, but when you dismissed it in March. I actually reached out because I didn't want to have my client waste money on a motion, sent her an email telling her to follow the court rules, you know, to make sure that it came back to the same place. She did the exact same thing again with the exact same complaint because she was looking for a different judge, right? And then now we're back here again. I understand it's filed. I understand he's filed an amended complaint, but my client has $3,675 in attorney's fees before today, right? You know, we've had 5 motions that are filed, I think 4 or 5. So at this point, Your Honor, I don't think the response is timely. I understand that sometimes we allow a little bit of leeway for people representing themselves, but I listened to you tell her in January and in March. I tried to explain to her after March, and I think having Mr. Holler file that yesterday while still not representing her, and then if he comes in a month from now, I'm going to be really upset, right? So now all of a sudden, you know, because if he was here today, you'd say to Mr. Holler, this isn't timely. And you know that. You're an attorney. And so if we're sitting here for a month from now and Mr. Holler comes into this case, or another attorney, then my client has definitely been harmed. Now, what's the harm to the case? At least the court costs and attorney's fees. And I get it. I understand that we're reluctant to do that sometimes, but I definitely have $3,675 for today. If this case does go forward and it's not dismissed, I ask for those court costs and attorney's fees. Thank you, Your Honor.
All right, thank you, counsel. So yeah, why am I just getting a First Amendment answer to the complaint? And the secondary question is, why was this filed a second time without giving notice that there was a previous case that had been dismissed, ma'am?
Is that question for me, Your Honor?
Yes, those 2 questions. Yes, ma'am.
After court, I immediately filed. I tried to get help from legal aid, housing, and Lakeshore legal aid. I was told they were shut down indefinitely. So I went to Attorney Holler. I had given him the paperwork, and I've done everything that he asked me to do. Now, I did speak to the attorney, but I don't even know how to go switch it to another judge. This is not my scope of practice. I was trying to get help. I did what he told me to do. He had me meet with him yesterday. I met with Attorney Holler several times trying to get this case together. So I didn't do anything out of spite or manipulation. And that's all I have to say. I did the paperwork. I went and got help. And just because he had to fit me in his schedule, I did what he asked me to do. And he filed the paperwork. I went and got help because I'm not an attorney.
Yeah, thank you. When you come to court, and you take it upon yourself to proceed in a court matter, you're required to find out what you need to do. And there's no leverage for you to not do what you're supposed to do because you initiated the action. And when you initiate the action, then that's on you. And if you are talking with someone that's going to help you and if they delay helping you, that's on you too. It doesn't matter. I don't have a rule that tells me that if a person doesn't have an attorney, that I'm to treat them as if they don't have an attorney. When you file a case, by filing that case, you say that I'm going to make myself competent enough to proceed with the matter. And obviously you've got some help. Help is a good thing, whatever way you want to go about doing it. The problem is that this has been delayed and delayed and delayed. And I believe that at the time that I dismissed the case, and I know that nobody likes for me to dismiss their case if it's something that they wish to go forward with. But of course, you know, the black robe does not excuse me from rules, just like the attorney is not excused from rules, just like the litigant is not excused from rules. If you don't bring a proper complaint, then that complaint is going to be dismissed because you can't proceed on it if it doesn't comply with the rules. Moreover, if a case is dismissed in front of me and you file the same case, that case is to come back to me. And on any complaint that you file, there is a place on the summons that asks you whether or not there was a pending matter. Now, one does not have to be a lawyer to be a reader. If you can read what it says. And if you read what it says, then you know what you are instructed by. And then moreover here, at least Mr. Groner has indicated to me that he sent an email giving some information as to what you might want to do if you file this case or refile this case. So all of those are the issues that's a part of this package. Obviously, the policy in the state of Michigan or the approach is leaning towards allowing matters to be decided on the merit. That's why I dismissed the case without prejudice, given the right to refile and bring the case, because obviously we want cases decided based upon the issues that are involved. But procedural issues can end the case if you don't follow the proper procedures. And whether you know those procedures or not, the moment that you come to court and file something, you have to learn what the procedures are. And Mr. Hollins, whoever it is that assisted you with some of this, one of the things that they missed critically, if you say that you talked to them a long time ago, was that you don't come the day before you come to court to file a First Amendment complaint. You know that there is a motion pending, and you know that this matter was set for hearing on today's date. This matter was set in March of 2024, and we're now, of course, in June, and the day before the hearing is when the complaint is filed. Technically speaking, I could disallow that altogether, and that would be the end of this case. And I have to grant it that there was some temptation to word that in. But I like the fact that you tried to exercise some diligence to get this done. But whatever didn't happen along the way, that's on you. That's not. If the attorney is not going to file his appearance in this, then that's on you. And there is something that is a bit amiss about partial representation, even under the rule where the attorney does not disclose that he is involved even in partial representation. To draft a document and to have it filed with the court and to not disclose that he has filed that document, that leaves that's some borderline stuff that might have some ethical issues involved. And I wish he was here so that we could address whatever those issues are. Then the final thing here is, in fact, that while all of this is going on, the attorney, the defendant in this matter, and the attorney for the defendant has to defend and continuously generate costs and fees because of the fact that this is being dragged along. I granted that Ms. Thomas is not a lawyer, but I can't hold her to a standard of not being a lawyer. We have no such standard. I have to hold her to the standard of being a litigant who initiated this action. And therefore, if you initiate it, you got to know what you want to do and you got to follow the rules. And the lack of following the rules has caused substantial delays with regard to this matter. So I will allow the First Amendment complaint and will set the case up going forward. But I won't do it without a sanction. And that sanction will be that $500 in costs would have to be paid to the defendant as a partial reimbursement for the expenses in this regard, as a condition of allowing the first amended complaint. To the extent that $500 in cost is paid, I'll allow a period of 2 weeks for that to be done. Today's date is the 10th, and so that's going to put it, must be paid by the 20th. Today is the 11th, must be paid by the 26th of June to plaintiff's attorney. If that is done, the court allows the complaint in this matter and sets this matter up for on a scheduling order that allows the parties to proceed by way of a scheduling order. This matter will be set for a pretrial. Now, what has to happen is that the $500 in cost has to be paid to the defendant in this matter, and I must receive confirmation from Mr. Groner that has been taken care of by the 26th, on or before the 26th of June. If that's taken care of, I will issue a scheduling order. I will send it out by mail. That scheduling order will have a return date in this matter of July the 31st. We have a return date of July the 31st. It will allow discovery through that date. And the hearing on the 31st will be at 9:30 a.m. Mr. Groner, you will need to reach out to my clerk to confirm or not confirm that you have received the payment by the 26th of June of 2024, and you have to get that payment in. If that's confirmed as an officer of court counsel, then the court will allow the amended complaint, and the matter will be set up on a scheduling order that requires the parties return on the 31st of July, and that opens discovery initially through that date. I will issue an order consistent with the same. That is my determination in this matter. I wish the parties well. Good day to you.
Can I say something, Your Honor?
Yes, ma'am.
I
Go ahead,
paid
ma'am.
Mr. Holler. I paid Attorney Holler March 20th, 2024. And I trusted that his judgment on this matter would be handled. That's why I went for help, because the other legal aid lawyers, they are closed indefinitely. So I didn't know that this wasn't done properly because I paid for help.
I understand that maybe you paid for help and so on and so forth, but I hope that you heard everything I said, because it sounds like you're missing a major, substantial part of what I said. Here's what I need you to
what he said. He knew what should have been done, and it wasn't done. And as a result,
I guess you took the opportunity to talk while I was talking. I didn't interrupt you when you were talking. I just don't allow it. Imagine what it would be like if judges allow people to talk over them. What kind of order would we have? That's no kind of order. Now, I don't say that to you to demean or disrespect you, not at all, not at all. But I think you're better than that. I listened to you when you were talking. When I'm talking, you don't interrupt me when I'm talking. You just can't do that. I mean, that's just not the way to do it. Now, here's where I think the issue is here. Yeah, you went to get some help. You've been trying to get some help, but you're responsible for this case. Until some lawyer puts their name in this and say that they are litigating this, then you're responsible, just like the lawyer on the other side is. You're acting as your own lawyer. You're in for work, and I've given some patience to that because I understand how that works out. But you can't, whether you use somebody to do it for you or whether you do it yourself, you can't come the day before your court date and file an amended complaint when the court set this hearing up 3 months ago. You can't do it like that. And moreover, it was a mistake to file the complaint without noting in the second case that there was a previous case. That resulted in the attorney having to file petitions to have the case removed from that court that it was sent to. And attorneys charge fees in order to do that. And counsel indicates that their defense of this has already amounted to some $3,500. The fact that is caused by the fact that you perhaps didn't know what you were doing does not take away the reality that there are expenses occurring on the other side. Now, I don't like the sound of that. None of that is pleasant. But that's the reality here. That's what's going on here. Now, you still get a chance to go forward with your case. You got to post the $500. You got to pay the $500 it costs. If you don't pay that, the case is dismissed with prejudice if you pay it, and we go to the next step. That is my order. I don't need to hear anything else from anybody else. Good day to both sides.